Good afternoon, everybody. Welcome to Doughty Street Chambers' final seminar on the Equality Act. Doughty Street has been celebrating the 10th anniversary of this most important act. And here in this final session, we're going to be looking at some of the key concepts and definitions not previously covered in the seminars before now, recapping on some of the key principles and issues covered in previous seminars, and also looking at some of the practical steps and tactics perhaps in bringing a claim under the Equality Act. Absolutely delighted today to have two speakers. The first is Leonie Hurst, who has a very wide-ranging practice covering everything from court of protection to prison work to immigration work, and is a very accomplished lawyer in both public law and civil claims. She's currently on the EHRC's B panel and is ranked as a leading junior by Chambers and Partners and indeed the Legal 500. Joining Leonie today will be Zia Nabi. Zia Nabi is a long-standing member of Doughty Street Chambers housing team, but also has a very strong practice in community care work, and in both respects has a very strong reputation in equality law and indeed bringing equality law challenges. He's also recognised by both of the directories, and I'm sure both he and Leonie will be bringing their wealth of experience to this seminar today, or webinar, I should call it. My name is Jamie Burton QC. I'm head of the Community Care and Health team at Doughty Street. I'm not actually joining you from Doughty Street today, but from my mother's house in the People's Republic of Scotland, where although we have many great things like a benevolent human rights culture, we don't appear to have very strong Wi-Fi connections. And so it simply won't sustain me being on video and audio. So you'll be spared having to look at me at any point during this webinar today. Anyway, you'll know the drill now, but you'll all have been automatically muted by Ray, who is our very wonderful assistant at Doughty Street, who's helping all of us present this webinar today. There will be an opportunity for questions. I'm going to, if that's okay, keep my Q&A chat open. And if you wouldn't mind just putting your questions in the Q&A, I'll be reading them as we go along. And then once Leonie and Zia have finished their presentations, I will then ask those questions on your behalf. But please do keep those questions coming, both as you're hearing from our speakers and indeed at the end. We've got an hour and a half for this session, but there's an awful lot to get through. So I suspect that we'll probably be hearing from Leonie and Zia for about an hour, and then hopefully we should have a good half an hour for questions afterwards. You're bound to have some, because of course the Equality Act is deceptively complicated. There are lots of issues in there, and Leonie in particular, I think, is going to be addressing some of the practical questions and issues that arise when bringing proceedings under the Equality Act, and I'm sure you'll have lots of questions in relation to that too. So without further ado, I'm going to introduce our first speaker. I think they're actually going to be sort of mixing this up a bit. So it's not going to be the case that you only hear from one and then the other. I think they're going to be taking it in turns. But I think kicking us off is Zia Nabi.
Well, good afternoon, everybody, and thank you for coming to this webinar. So the Act, as you will all be aware, is a comprehensive and lengthy Act. It has 16 parts, it has 218 sections, and it has 28 schedules. And it's a bit of a treasure trove in that I'm always discovering sections that perhaps I hadn't focused on previously. One thing to note, though, is that part 1 of the Act, which relates to the socio-economic duty, is in force in Scotland, but is not in force in England, which is a real shame because discrimination by reason of socio-economic disadvantage is plainly something that is becoming increasingly evident, and is also getting increasing airtime. Ray, I wonder if I could have the next slide, please. So I'm going to just very quickly sort of go through the structure of the Act. And part 2 of the Act sets out the key concepts. And part one of that are the protected characteristics. This is what the Act seeks to protect. And you'll see age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. Now, it's evident, self-evident, that every one of us has a protected characteristic. We all have an age. We all have a race. We all have a sex. So the issue is whether there is a protected characteristic has become an operative factor in any prohibited conduct. That's what the Equality Act is there to focus on, is to guard against prohibited conduct which falls in respect of the protected characteristic. So if I may have the next slide. So what is prohibited conduct? And that's set out in part 2, chapter 2. Sorry, that should be part 2, not part 1. So this is what is prohibited. Direct discrimination, discrimination arising from disability, which can be direct, but is thought important enough to have its own section, because sometimes it's not clear as to why someone is being discriminated against, whether it's because of their disability or not. Indirect discrimination, where something doesn't appear to be discriminatory on its face, but ends up having a discriminatory effect. The other side of that coin, as it were, which is discrimination by failing to make reasonable adjustments, harassment, and victimization. So those are the types of conduct that are prohibited from the Act. Some are absolutely prohibited, and some may be justified and may be deemed to be proportionate, and that's what the Act seeks to explain. May I have the next slide? And another way of looking at the Act is, what are the Act's spheres of activity? Where is the Act functioning? Well, its spheres of activity are services and public functions, premises, work, education, associations, and transport. So it defines, the Act itself defines where it is going to matter. May I have the next slide? In terms of services and public functions, that is set out at part 3 of the Act, and in particular section 29. It applies both to public functions and the provisions of services by a public authority. It's relevant to note that section 29 doesn't apply to the protected characteristic of age of persons who are not yet 18. And also there's a cascading effect. So part 3 does not apply to discrimination, harassment, or victimization that falls within either part 4, part 5, or part 6. And that is not insignificant, because sometimes, as we will see, an Act could arguably fall either within part 3 or part 4, where the duties are slightly different. So it is of some importance as to which part of the Act you come under. And part 4 is in relation to premises and the management of premises. It doesn't apply to age, and itself doesn't apply to discrimination, harassment, or victimization that is prohibited by part 5, which is work, or part 6, which is education. And in particular, it is to be noted that section 35 instructs a person who manages premises not to discriminate against occupiers. So although I'm not going to go all through the Act, you will see that what we have here are interlocking sections and provisions which seek to prevent inequality of treatment by reason of a protected characteristic, unless it can be justified in some situations. Can I have the next slide, please? And then two other parts to look at, Part 9 and 11. Part 9 of the Act relates to enforcement, how you enforce your rights under the Act. The jurisdiction is given to the county court, but it doesn't prevent a claim for judicial review. So in the sense that you can raise an Equality Act breach in a claim for judicial review. The time limit is 6 months, but again, as we're going to examine, there is the concept of a continuing act, so the time limit doesn't start to run until the continuing act stops. Remedies, and I don't think remedies have been as explored as they may have been, because Section 119 says that the county court can grant any remedy that could be granted in proceedings for tort or a claim for judicial review. And that's quite startling, because it gives a county court judge in an Equality Act case the same power as a judicial review judge. So the judge could make a mandatory order, the judge could make a declaration, could grant an injunction, and the judge could, in appropriate circumstances, grant interim relief. There's also the concept of burden of proof, which I know Leonie is going to address. But basically, if you establish a prima facie case of discrimination, then the person who's complained against has got to prove that they didn't unlawfully discriminate. And that can be important. And then Part 11 deals with advancement of equality and the public sector equality duty. I think looking at the cases on the public sector equality duty, I mean, in my view, they don't all speak with one voice. So when judges want to, they call it a duty of process, which it undoubtedly is, and not a duty to achieve a specific result. And yet there are cases where the public sector equality duty, particularly in homelessness cases, where the public sector equality duty actually has a material bearing on the result. For example, when you're assessing if accommodation is suitable for a person, the public sector equality duty can make a material difference to the outcome of that decision, the outcome of that question. And the public sector equality duty, of course, requires the authority to have due regard to the need to advance equality of opportunity, which is not the same as preventing discrimination, and to remove and minimize disadvantages. So in the right case, it is a very powerful tool. May I have the next slide? I'm going to very quickly go through this because you'll all be familiar with this. Each protected characteristic is defined. So disability is defined in Section 6, physical and mental impairment. It's got to have a substantial and long-term adverse effect on the ability to carry out normal day-to-day activities. Substantial simply means more than minor or trivial, and long-term means it's lasted 12 months, is likely to last at least 12 months, or is likely to last the rest of the person's life. May I have the next slide? Important to note that the impairment doesn't need to be diagnosed or clinically recognized disorder, because what you're looking at is the effect of the impairment. And if you look at the effect of an impairment, you can then conclude that there must be an impairment that is causing those effects. And so when you're considering whether or not a person is disabled, what you've got to look at is what the person can or cannot do, and what they can only do with difficulty or with adverse consequences or prompting. That's a case of aderemi. Now, importantly, the effects of medication or treatment must be disregarded. Now, I don't know about Jamie and Leonie, but I've had a number of cases where the public authority has concluded in terms that a person is not disabled, but have ignored the positive effect that medication or treatment has had on them. And by having concluded that a person is not disabled, they've ignored the public sector equality duty and they've ignored other obligations under the Act. So whenever you are looking at disability, always check that the decision maker has taken into account and directed themselves that the effects of medication or treatment must be disregarded. May I have the next slide? Thank you. Going through the protected characteristics, the gender reassignment, section 7, it's interesting looking at the equal treatment bench book. Although the Act itself uses the term transsexual, the equal treatment bench book, which is given to all judges, says it is preferable to use the term transgender if it is necessary to the legal proceedings to refer to a person being transgender at all. And this shows how language has evolved and concepts have evolved even since the Act was passed in 2010. May I have the next slide? Race. And race is very broadly defined. It includes color, nationality, ethnic or national origins, and includes people who are of a particular racial group. May I have the next slide? Then religion or belief. So religion means any religion, but it also includes a lack of religion. So having a lack of religion can also be covered under the protected characteristic of religion. And belief means any religious or philosophical belief. And a reference to belief, again, includes a reference to a lack of belief. So that, as many of you will be aware, has been very topical recently in the Forstater case, which is something that we're going to look at in a moment. But it's just worth looking at section 10, and in particular, how it defines belief. It's any religious or philosophical belief. And it also includes reference to a lack of belief. May I have the next slide? What counts as a belief? And the courts, in a case of Granger and Nicholson, some nearly 10 years ago now, over 10 years ago, set out 5 tests for what counts as a belief. And they've come to be known as the Granger Tests. So the belief's got to be genuinely held. It can't be held as a joke or for satirical purposes. It's got to be genuinely held. It's got to be a belief and not an opinion or viewpoint. So it's not something that you necessarily arrive at rationally, but it is something that is a belief. It must be a belief as to a weighty and substantial aspect of human life and behavior. So it can't simply be a belief, for example, that cheese and onion crisps are better than salt and vinegar. That wouldn't qualify. There must be a certain level of cogency, seriousness, cohesion, and importance. It must attain that. And that's because this is a serious matter. The Equality Act is a serious act. And so it's trying to weed out beliefs that don't satisfy these tests. And finally, and importantly, and perhaps controversially, it must be worthy of respect in a democratic society, be not incompatible with human dignity, and not conflict with the fundamental rights of others. And so you can immediately see that raises a number of questions, because a generally held belief, Granger 1, could be worthy of respect Granger 5, but could also be incompatible with human dignity and could also be in conflict with the fundamental rights of others. And this is something that the courts have been asked to address, and we'll come on to that in a moment. May I have the next slide, please? This is a protected characteristic of sex, reference to a man or a woman. Next slide, please. And so some of the issues we've been discussing have recently been dealt with by the Employment Appeal Tribunal, Ms. Justice Chowdhury, in the case of false data against CGD Europe and others, which I suspect most, if not all, of you attending this webinar will be aware of. And the question in this case was a belief that sex, i.e. biological sex, is immutable and not to be conflated with gender identity, a belief within the meaning of Section 10 of the Equality Act? Could that be a valid belief and therefore a protected characteristic? The claimant, Ms. Forstater, said that it was a belief and that she was discriminated against at work because of her belief. So there's a preliminary hearing as to whether her belief was a protected characteristic. And the Employment Tribunal held that it wasn't a belief. And that's because any belief had to be worthy of respect in a democratic society, not be incompatible with human dignity, and not be in conflict with the fundamental rights of others. And the Employment Tribunal held that Ms. Forstater's belief fell foul of Granger 5 and therefore didn't come within the protected characteristic definition in the Equality Act. May I have the next slide? The Employment Appeal Tribunal allowed Ms. Forstater's appeal, finding that her belief was a protected characteristic. And what the AAT said was that the belief's got to relate to matters that are more than merely trivial. The belief must possess an adequate degree of seriousness and importance, must be a belief on a fundamental problem. It must be coherent in the sense of being intelligible and capable of being understood. But, said the EAT, the test should not be set at a level which would deprive minority beliefs of the protection that they are intended to have. So the EAT said that Granger 5 was satisfied. May I have the next slide? So when would a belief, a philosophical belief, be excluded under Granger 5? And EAT said, well, it would only be excluded if it was a kind of belief, the expression of which would be akin to Nazism or totalitarianism, or espousing violence and hatred in the gravest of forms. And the way EAT reasoned the judgment was that it was a belief that would fall outside the scope of Article 9 of the European Convention, which, as you are aware, gives a qualified right to freedom of thought, conscience, and religion. Ms. Justice Chowdhury said that there were extremely limited circumstances in which a belief would be considered so beyond the pale that it would not qualify for protection at all. And the judgment noted that the claimant's gender critical beliefs, which were widely shared, and importantly, which did not seek to destroy the rights of trans persons, did not fall into that category. So the claimant's belief, while offensive to some, and notwithstanding its potential to result in the harassment of trans persons, in some circumstances, fell within Section 10, and so was a protected characteristic. May I have the next slide? It also noted that the fact that the claimant did not share the gender identity belief was enough in itself to qualify for protection, because that could be qualified as a lack of belief for the purpose of Section 10. So the court reasoned it in two ways. That Ms. Forsetta both had a belief about sex being immutable and had a lack of belief in that she did not share the gender identity belief. But the court warned that even though it was a belief that fell within Section 10, the claimant was subject to the same prohibitions on discrimination, victimization, and harassment as the rest of society. So having a belief is not a trump card. And the fact that any act of misgendering was a manifestation of a belief falling within Section 10 would not automatically operate to shield her from liability under the Act. It is a careful judgment. It is a nuanced judgment. It is a difficult dialogue with strong views on both sides. And in my view, what the court has tried to do is set out a test which protects minority beliefs of all sorts, which have the necessary seriousness and coherence from people who have those beliefs from themselves being discriminated against under the Equality Act, whilst at the same time giving a stern warning that does not, just simply having a belief doesn't allow you to then to conduct any action that breaches the Act itself. May I have the next slide? Yeah, I'm going to again go through some of this fairly quickly. So to the direct discrimination, A discriminates against B if because of a protected characteristic, A treats B less favorably. And so that would be, for example, if a shop said we will not serve any Muslims, that would be direct discrimination. Most cases, you will not be surprised to hear, are not direct discrimination cases. Now, there are some, but it's really indirect discrimination where the Act has been used most. And I know in the previous seminar, our colleagues addressed indirect discrimination, and this seminar today is not intended to go over that again. May I have the next slide, please? Then there is a discrimination arising from disability. It's not quite the same. It's similar to, but not identical to, direct discrimination. And it says a person A discriminates against a disabled person if A treats B unfavorably because of something arising in consequence of B's disability. Well, how conceptually does that differ to direct discrimination? Well, a very simple example would be this. Let us say that a landlord treats people who display antisocial behavior unfavorably, all people. But if the antisocial behavior is because of someone's mental health issues, which amount to a protected characteristic, then that wouldn't be direct discrimination, but would fall within Section 15 because the antisocial behavior arises in consequence of mental health issues. And then the landlord would have to show, well, the unfavorable treatment is a proportionate means of achieving a legitimate aim. So this gives specific and additional protection to people with the protected characteristic of disability. May I have the next slide? Indirect discrimination. And this is where a lot of battles have occurred. So indirect discrimination is where a rule on its face appears not to be discriminatory at all. It appears to be rational, appears to be fair. But what happens is that the application of that rule, that provision, criteria, or practice, and it's 2B, puts persons with whom B shares the protected characteristic at a particular disadvantage. So prima facie, it seems fine, but in operation, it puts B at a particular disadvantage. Now, when that happens, then A would have to show that the disadvantage is a proportionate means of achieving a legitimate aim. And it would have to do that by evidence, which again is something that Leonie will address. May I have the next slide, please? Section 20 leads on from section 19, and that's where a PCP puts a disabled person at a substantial disadvantage in relation to a relevant matter where persons who are not disabled, then A is under a duty to take such steps as is reasonable to have to take to avoid the disadvantage. So you will see here, section 20 is building an additional protection where you have the protected characteristic of disability. And it's important to bear in mind that substantial simply means more than minor or trivial, that disadvantage is not defined in the Act, but it includes denial of choice. And the EHRC Services Code says it is enough that the person can reasonably say they would have preferred to have been treated differently. May I have the next slide? Now, PCP itself is not defined in the Act. What amounts to a provision, criteria, or practice? In the case of Ishola and the London of Transport for London, forgive me, the Court of Appeal held that provision, criteria, and practice was simply ordinary English words. And what all three words carried was the connotation of a state of affairs, whether they were framed positively or negatively, and even if they're only informal, indicating how similar cases were generally treated, or how a similar case would be treated if it occurred again. So you needed some form of continuum, but it didn't mean that the PCP or practice had been applied to anyone else. So a one-off a one-off state of affairs could amount to a PCP if the court concluded that this would be how anyone else would also be treated. Can I have the next slide? So the failure to comply with the duty at section 20, the duty to make reasonable adjustments for disabled persons, constitutes discrimination. Now there's a key thing to note here, because I often see failure to make reasonable adjustments pleaded and argued. There is a key difference between whether a claim falls under Part 3, which you'll remember is the services and public functions part of the Act, and Part 4, which is the premises part of the Act. If the claim falls within Part 3, there is an anticipatory duty on the authority to make reasonable adjustments. If the claim falls under Part 4, then the duty only applies if A received a request to take steps to avoid the disadvantage. And often there will not have been a request, and therefore a key question does become in a case, is whether the claim falls under Part 3 or Part 4 of the Act. May I have the next slide? So in a Part 3 case, under section 29, a person must not, in the exercise of a public function, a provision of a public service, do anything that constitutes discrimination. And a duty to make reasonable adjustments applies to a person who exercises a public function, provide the service. And that includes a duty to make anticipatory adjustments for a class of people, as well as a continuing duty to make adjustments in individual cases. So it bites in two ways. Firstly, anticipatory duty to make adjustments, and secondly, in an individual case, a continuing duty to make a reasonable adjustment without request. The Statute Code of Practice states, don't wait until a disabled person wants to use a service before you give consideration to the duty to make reasonable adjustments. Service providers should anticipate the requirements of disabled people and the adjustments that may have to be made for them. May I have the next slide? So, but under Part 4, again, failure to comply with the duty to make reasonable adjustments constitutes discrimination, but the duty only applies if the landlord or the person in control of the premises receives a request from or on behalf of the tenant or a person entitled to occupy the premises to take steps to avoid the disadvantage. And section 32, subsection 3, it says part 4 does not apply to the provision of accommodation if the provision is for the purpose only of exercising a public function or providing a service to the public or a section of the public. So you will see immediately that where a local authority provides housing, whether under its allocation scheme or under its homelessness duties, does that fall under part 4 or does that fall under part 3? Arguably, if the provision of accommodation is not only for the purpose of exercising a public function, then part 4 would apply. But if it's only to exercise the public function, then we're within part 3 and the advantages that has. May I have the next slide? I'm just going to quickly deal with what harassment is. A person harasses another if it engages in unwanted conduct related to relevant protected characteristic and it violates B's dignity or creates a hostile environment. Sexual harassment is explicitly deemed to be unlawful. May I have the next slide, please? And victimization, a person victimizes another person if A, subjects B to a detriment because A does a protected act or A believes that B has done or may do a protected act. So for example, if B complains of being discriminated against, that is a protected act. And if you are subject to a detriment because of that, that amounts to victimization. Note though, at 27 subsection 3, an allegation in bad faith is not a protected act. May I have the next slide? Just going to refer very briefly to the case of Noor and Birmingham City Council. So this was a housing allocations case, challenging the council's allocations policy as being unlawful. Now, just very briefly, the facts in this case were that the claimants were mother and daughter. Daughter was an adult dependent child, and she had cerebral palsy, and she was significantly disabled, and it was determined that she could only live in adapted or adaptable accommodation. And the council also had a policy or practice which said that houses would be given to persons with children under the age of 18. Now you can see that there was a problem here because firstly, houses are more easily either adapted or adaptable. And secondly, if people who have disabled members are more likely to be in households where there are no children under 18, then they are going to be prevented effectively from being allocated accommodation. Council argued in this case that the allocation of accommodation fell under premises because it wasn't ancillary to the discharge of any other function, and therefore it had no duty to make any reasonable adjustment until it received a request to take steps to avoid any disadvantage. And the claimants argued that the allocation of accommodation was only an exercise of a public function, and so no request was necessary. May I have the next slide? The judge found that allocation of accommodation came under part 3. He said, in my judgment, the effect of section 32(3) is to exclude part 4 entirely from the function of providing accommodation by a person who is doing the providing of accommodation solely either in the exercise of a public function or where the provision of accommodation is made to the public or a section of the public. He noted, he said, if the person is providing accommodation for multiple purposes, only one of which is the exercise of a public function, then part 4 applies. and the accommodation provider is treated under the Equality Act in the same way as any other provider of accommodation. May I have the next slide? So I'm going to pass on now to Leonie, who is going to talk about formulating a claim.
Right. Thanks, Zia, for that very comprehensive outline of the Act. I'm going to be a bit shorter, but I am going to focus on some of the practical issues which arise when formulating and conducting a claim. And this is an outline of what I'm going to address. So the first real issue is, what is the form of discriminatory conduct that is complained of? And in some cases that will be very obvious. But as Zia referred to earlier, often there can be confusion between direct and indirect discrimination. And the first thing that needs to be said is conduct cannot both be direct and indirect discrimination. And what often helps to distinguish between the two forms of discrimination is to focus on the causal link between the protected characteristic relied on and the behaviour complained of, and also the focus on the distinction between the conduct or behaviour itself and on the effect. So although in direct discrimination there's a need for a causal link between the unfavourable treatment and the protected characteristic, the word uses because of the protected characteristic, there in indirect discrimination there's no need for that causal link, only a need to show a discriminatory effect of a neutral provision. And clearly where the conduct or behaviour that's complained of has the intent or purpose of discriminating, of producing an unpleasant environment, of treating someone less favourably because of a protected characteristic, then you're looking at direct discrimination or victimisation, harassment, that kind of behaviour. And although there will be cases where the distinction is very obvious, there will be other cases where it's really not. So James is a case involving pensioners who were entitled to free swimming at the local authority baths. And of course, the differential pension age meant that a man who was age 61 was not entitled to free swimming, although a woman age 61 would have been. And the claim was brought initially as an indirect discrimination claim, but the House of Lords held that the claimant had been discriminated against directly on grounds of sex, because if he had been a woman aged 61, he would have been entitled to the free swimming. And of course, how you frame it is relevant also to the availability of defences for the defendant, and we'll come to that in a bit later. The second major issue that happens in indirect cases and in reasonable adjustments cases is how the PCP, the provision, criterion or practice, is framed. And I'll address that in some detail. How do you demonstrate detriment, the adverse impact of the discriminatory conduct complained of? Selecting the comparator and dealing with any causation issues. The burden of proof, we'll come to evidence gathering, and last but not least, defences available under the Act. Next slide. So framing the PCP, this is fundamental to the claim if you're going to bring either an indirect claim under Section 19 or a reasonable adjustments claim under Section 20. And obviously what's needed is that you show a provision, criterion or practice which has a demonstrable adverse effect on the person concerned, either by comparison to other individuals or by comparison of relevant groups. And obviously it's trite to say that you need to define it carefully, but it is very common for the PCP either not to be defined or not to be defined clearly and closely enough to enable the court to draw conclusions. And whether in fact there is a PCP and what it is a question of fact for the court or tribunal. So it doesn't have to be an express or formal policy or procedure. The court can infer from what's actually happened in practice, how individuals and groups are treated. And what's meant by practice, Well, we've seen from Ishola and Zia showed you the longer quote earlier. It's a state of affairs indicating how similar cases either are generally treated or would be treated if the situation recurred. And that raises the question of whether a one-off decision can count to be a PCP. And formally, the courts doubted that a one-off decision could constitute a PCP. But in fact, when one's looking at Section 19 and indirect discrimination, the phrase that's used in Section 19 is involves would apply, so it envisages that there will be not only situations where the PCP has been applied, in fact, but where it would potentially apply to, or would potentially have that effect if applied. So I think that you can bring some one-off decisions into a PCP if you can show that, although there's only been one instance of this particular decision, there would be similar instances arising in future. So of course, it's obviously more likely to apply where there's a provisional criterion which has been applied once, but would potentially be applied again. The PCP, and this is the most important aspect of defining the PCP has to be neutral. So the content of the PCP has to be neutral and its purpose has to be neutral. If the PCP as defined is linked inextricably with a protected characteristic, or it's imposed for discriminatory purposes, then you're not looking at indirect discrimination or reasonable adjustments, you're looking at direct discrimination. And it must not be circular. So Bailey was a case where the EAT was quite critical of the way in which the employment tribunal had approached the case, because they had essentially found that membership of a privileged group, in this case men, membership of a senior officers group was a precondition for enjoying the privileges of being a senior officer. And the argument was entirely circular. So essentially you're saying being a man is a prerequisite for enjoying the privileges of being a man. So it is relatively easy in some claims to formulate the PCP in a neutral way, but in other claims it will be much more difficult. So if you're having difficulty in divorcing, in finding a neutral provision which has been applied, or practice which has been applied, then think again about the basis on which the claim is put. And in indirect discrimination, and indeed in reasonable adjustments, it's not necessarily that the PCP has in fact been applied to C, but that it would be applied, but it must be applied or applicable to others as well. Next slide. So once you've decided how to put your claim and you've framed the PCP if you need one, how do you demonstrate adverse impact? Well, the first question is, of course, what do you need to show? So direct discrimination requires less favourable treatment. And again, there's a causal relationship between the less favourable treatment and the protected characteristic relied on. Discrimination arising from disability similarly requires unfavourable treatment. And indirect discrimination has a two-stage test. So first of all, you have to demonstrate that there is a particular disadvantage to groups with a protected characteristic versus other persons without that protected characteristic. And you also have to show, and this is what is often forgotten, that the individual claimant not only has the protected characteristic, but was also put at that disadvantage or would be put at that disadvantage. So indirect will refer potentially either to actual disadvantage, which has been experienced, or potential disadvantage, which would be experienced were the PCP applied. Reasonable adjustments, you're looking at the individual being put at substantial disadvantage compared to others without that disability. So there you're comparing the individual with the group, as distinct from indirect, where you're comparing groups with groups and then showing that there's a particular impact on the individual. So you can see, obviously, how you frame the PCP and how you select your comparator is really important. And often that you'll find that how you define the PCP will determine both who your comparator group is and the evidence that you're looking to get. But there are particular considerations where you're looking at disability. So the comparator group in disability cases is a group or persons with that particular disability. So, for example, if the PCP is providing information leaflets with different spoken languages but not easy read, then someone with a learning disability or cognitive impairment is at a particular disadvantage, whereas someone with a physical disability but without cognitive impairments won't be at that physical disadvantage. So it's sometimes you will need to, particularly in disability cases, you'll need to define your comparator group within the relevant group with a protected characteristic. It can be much narrower. And there can be more than one appropriate pool of comparators, in which case the court, it's open to the court to decide which one it wants to use to make the relevant comparison and draw inferences. And you need, depending on the case, to decide whether you've got sufficient evidence on the facts of the individual case to demonstrate an adverse impact, or whether you're going to need broader evidence to demonstrate that there is a disproportionate impact on either on individuals or groups. Excuse me. Next slide. So the burden of proof, this is something that Zia referred to earlier. Section 136 of the Act essentially incorporates the previous common law test in Eigen and Wong, and that's a two-stage test. So the first stage is an evidential burden on the claimant to demonstrate a prima facie case on all the facts. So that includes all the evidence that's been put in by the defendant or respondent. And if then, looking at all those facts, the court can decide, in the absence of any explanation, that discrimination has occurred, the burden just shifts to the defendant to provide an explanation, essentially, to demonstrate that there hasn't been any discrimination on the balance of probabilities. And the court can draw adverse inferences, and frequently, obviously, does. Bayes Children's Wear is an example of how not to defend an employment claim where essentially the employer lied consistently and persistently about the actual reasons for the dismissal of a black employee, as a result of which the court concluded that the lying itself was discriminatory conduct, from which it could deduce that the actual reason for the dismissal was discriminatory. Next slide. So what evidence might you need? So there will be cases where, particularly in direct discrimination cases, where you don't need to demonstrate any broader evidential basis for the claim. So where, for example, someone has been subject to less favourable treatment on a basis of a protected characteristic, all you will need to do is prove a prima facie case that that conduct occurred and the reason for it. So you'll need to demonstrate both the conduct and the causal link. But in reasonable adjustments claims and in indirect discrimination in particular, often what you'll need is broader evidential basis to show the disproportionate impact on a particular group, so persons with a particular characteristic. It's worth noting, having said that Section 19, the indirect discrimination wording, was intended to do away with the need for statistical comparisons where no statistics might exist. So the previous wording in the DDA was really very technical and led to some really tortuous statistical comparisons. The idea behind Section 19 is that it should be possible simply to demonstrate facts from which the tribunal can infer a disproportionate impact, and then the burden shifts to the defendant. But there will obviously always be cases where further evidence is needed about the evidence on the impact of the PCP on particular groups. So where might you get that evidence? Well, public authorities will be subject to public sector equality duty monitoring duties, and public sector employers are required to publish that data. So where it's an employment claim, you will see statistics from which it can be very easy to demonstrate a prima facie case of discrimination. You may find that there are publicly available statistics, national and regional statistics, and again, many public function bodies provide statistics on the operation of their functions, broken down by protected characteristic. You may need to provide expert evidence, in particular where the court needs to hear an explanation of why a particular measure, a particular PCP, is likely to have a disproportionate effect on someone with a protected characteristic. So that might be, for example, expert evidence about particular religious practices or particular racial characteristics, particular health problems which are confined to, or disabilities which are confined to or disproportionately present in particular groups. So always bear in mind that you may need, it may get you there very quickly to have an expert provide some evidence to help the court understand where the disadvantage comes from and how the adverse impact arises. Not to forget Freedom of Information Act requests, obviously a potentially very powerful tool, although there is obviously going to be a time lag in receiving that information, which may make it difficult to bring the claim fully formulated in time. Similarly, with subject access requests for private data, that can often provide some surprisingly useful information about the actual basis on which decisions have been taken, and can sometimes illustrate differential treatment between the particular claimant whose data you're accessing and others. And of course, you can always request information in your letter before action. So while the courts deprecate phishing requests, it is entirely proper and possible to seek in the letter before action, setting out what you think has gone wrong, disclosure as to statistics or relevant policies that you think will be potentially helpful for the claim. And of course, in public proceedings, in judicial review, there is an ongoing duty of candour at every stage of the proceedings, including before action, on the public authority to disclose both information which they rely on and also information which assists the claimant's case. And last but not least, a request for further information in civil proceedings and also in judicial review. It's being used increasingly. That's a formal procedure by which the defendant can be asked further questions about aspects of their case. That can be used pre-action, but is usually used after pleadings have been exchanged. Next slide. Defences. So there's no defence to direct discrimination under the Act, but there are defences to other sections of the Act. In particular, I'm going to look at Section 19, Justification, and issues of awareness arising in disability cases. So Justification is a defence both to discrimination arising from disability. It's a defence to indirect discrimination, and contrary to what I just said, it's a defence to Section 13 direct discrimination, but only in relation to age as a protected characteristic. And the defence is available where the defendant can show that the conduct is a proportionate means of achieving a legitimate aim. So that is an objective test. It has to be supported by evidence. So it's not sufficient for the defendant simply to say, well, we have this policy and we think it's a good one, and it hasn't caused any problems so far. It has to be a proper evidential assertion demonstrating that there hasn't been a disproportionate impact. So what's a legitimate aim? It's one that is legal, non-discriminatory, real and objective. So costs or resources don't by themselves satisfy that test. You can't discriminate and justify it on the grounds that it's cheaper to do so, unsurprisingly. What does proportionality mean? Well, both the legitimate aim and the proportionality parts of the justification defence are taken from European case law, and a similar test is imported. So you have to show that both that the measure is appropriate and necessary to achieve the legitimate aim that you've identified, but also, and really, this is really important, that there's no less discriminatory form of achieving it. So it's really important that the court is reminded of that necessity and least restrictive principle, because there is some question in some of the case law and indeed in the statutory guidance as to whether proportionality involves a balancing exercise. And my view is that that is really the wrong way to approach it, because what balancing exercise encourages is the court weighing the benefits and disbenefits of the measure, rather than looking at what's the aim that this is intended to achieve. Is it necessary to achieve that aim? Could the aim be achieved or pursued in any less discriminatory fashion? And that's the structured, proper structured approach to proportionality. So I think the statutory guidance is wrong on this, but it's important to focus the court's mind on the particular elements of proportionality. Next slide. So in reasonable adjustments claim, what's required is by the duty is to take reasonable steps to avoid disadvantage. And it can be a defence to show that the steps that are required would fundamentally alter the nature of what you're doing. So for a public authority, they're outside your powers, or for a service provider, they would fundamentally alter the nature of your service or your association. Those won't be reasonable steps. And in other cases, the duty will can be defended where the step that's been identified would not be reasonable for the particular defendant. And that's a question which depends on all the circumstances of the case, including, not least, whether that particular step would be effective in reducing or avoiding disadvantage. But more importantly, the practicability of taking that step, the costs, the disruption of doing so, and the resources available to the particular defendant. So the example that's often given is where you have a small individual post office which needs to communicate with individuals whose hearing is impaired. It may be reasonable for them to communicate by written notes. It's unlikely to be a reasonable step for a much larger post office where there's greater resources and much more technology available. And lack of awareness is a defence to Section 15, discrimination arising from disability, where the discriminator did not know of the claimant's disability. But it's important to stress that lack of awareness is not a defence to a reasonable adjustments claim. It's often, you'll often find defendants in civil claims will say, well, we didn't know that the claimant was disabled in this particular way. But that is not a defence to a reasonable adjustments claim. So just be aware of that and watch for it. Next slide. And last but not least, associated ancillary duties. So these are duties which are not expressly contained within the Act, but they arise from and are implied by the statutory equality duties. So the first one, and they're both very important parts, particularly of public law discrimination claims, but also have real impact in private law claims. The first one is the anticipatory nature of the duty. So reasonable adjustments in particular, service providers and public persons exercising a public function have to think about reasonable adjustments in advance of actually encountering anyone with a disability, and to take reasonable steps. So that's not a duty to consider any and all disabilities which might arise or be encountered, but in general to consider how the service or the public function is delivered or exercised, and consider what steps can reasonably be taken to mitigate disadvantage as and when disabled persons seek to use that service or function. And similarly, the public sector equality duty is an anticipatory duty and an ongoing duty. So it has to be considered, the statutory factors in the PSED have to be considered both before and during individual decisions and in policy formulation. So it's not simply, as it's often treated as a one-off box ticking. We carried out an equality impact assessment, and that's done. But in fact, what has to happen is each time a decision is taken which has equality implications, before that decision is taken, the PSED has to be applied and the duty has to be exercised. And importantly, it has to be, in the famous words of Bracking, exercised in substance, with rigor and with an open mind. And that's actually a very substantially different exercise of the duty to what we often see. And a failure to take steps in advance of a decision or in advance of policy formulation may prevent a defence being available. So scrabbling at the last minute to mitigate a disadvantage is all very well, but where it was obvious that a disadvantage might arise, that's not going to work. And particularly in public law claims, that can be a very powerful way of putting the argument. And the second aspect of the duties arising from the Act is that of monitoring and review. So and that applies particularly to reasonable adjustments in the PSED. It's not simply a one-off. Once you've considered how to provide your service or to exercise your public function with steps to mitigate disadvantage or avoid disadvantage, that's not sufficient. That duty and the exercise of the duty has to be kept under review, not least because circumstances change. There may be changes to the PCP for reasonable adjustments, which mean that the nature of the disadvantage changes. So, for example, where you're having building work done, but it also the reasonableness of the steps may change as well. So where technological advances suddenly make it easier, for example, to attend online hearings, then that can affect the reasonableness of the adjustment that needs to be made. And the PSED, again, is an ongoing duty, must be exercised in substance with rigour and an ongoing an open mind, and it has to be evidenced. So the need is to keep records of what is being considered, what is being done, to show that the public authority has complied with the PSED. And again, that can be an extremely powerful tool in public law claims. So I'm now going to hand you back to Zia to talk about how to bring the claim.
Thank you very much, Leonie. Right, well, bringing the claim, we can go through this quite shortly, I think. So the Act gives a very strong steer that the correct forum for bringing an Equality Act claim is the county court, saying that the county court has jurisdiction to determine a claim to contravention of Part 3 and Part 4, but explicitly says that this doesn't prevent a claim for judicial review being made. Claims got to be brought within 6 months or such other period as a court thinks just and equitable. So the court does have a discretion to extend time, but where possible, it would be advisable to bring the claim within the 6-month period, but bearing in mind that conduct extending over a period of time is to be treated to be done as at the end of the period. Therefore, if there is a continuing discriminatory act, that elongates the limitation period. May I have the next slide, please? And note the practice direction, which came in April 2020, that if you do bring proceedings under the Equality Act, whether it's in the County Court or the High Court, the claimant must give notice of the commencement of the proceedings to the Commission and also file a copy of that notice with the court. And the Commission can then decide what, if any, steps they want to take in respect to the claim that's being brought. Actually, my experience so far is that generally they will note that the proceedings are being brought, but will more rarely actually take step themselves. May I have the next slide, please? So again, administrative court or county court, and in the case of Hamlet and Essex County Council, the court said the clear intention of Parliament is that claims under Section 29, you'll remember Section 29 is where a person would be alleging discrimination against a local public authority in the exercise of a public function or the provision of a service to the public. Well, this case says the clear intention of Parliament is that those claims must be brought in the county court. And in particular, and this has to be right, the administrative court is not well suited to hear factual disputes, the sort that may arise under Section 29. And also it's worth bearing in mind, of course, that you won't get permission for a judicial review where there is an adequate alternative remedy. Having said that, I've certainly been involved in judicial reviews where the breach of the Equality Act has been a significant part of the judicial review, and it has not been an issue that the administrative court is the right court to hear the claim. And remember, of course, the administrative court also has the ability at the end of any hearing to hive off any factual dispute to be heard in the county court. May I have the next slide? Assessors. So the court has the power to appoint one or more persons of skill and experience in the matters to which the proceedings relate as assessors in any case. The power under Section 63 must be exercised, i.e. the power to appoint an assessor must be exercised unless the judge is satisfied that there are good reasons for not doing so. Now, this is dying out, but until fairly recently, the courts would approach this, certainly in the county court, the other way around. They would not say, why should an assessor not be appointed? Rather, the question at any directions hearing would be, why do you need an assessor? As I say, I think that practice is now dying out, but it is important, I think, for assessors to be present in most cases who are experienced in discrimination matters, because they can very often assist the judge in wading through the complexities of certainly the evidential complexities of a case where discrimination is being alleged. And the code itself says, because often judges say, I don't need an assessor. The code says, code of guidance says, it would not be a good reason that the court itself believes that it can hear the issues without an assessor. May I have the next slide? Remedies, and I think I touched on this earlier. The county court can provide any remedy that could be granted, either in a tortious claim or in a claim for judicial review, which means it can grant quashing orders, mandatory orders, and declaratory relief. So it's very wide-ranging power. The court could also award damages, which may include compensation for injured feelings, whether or not it includes compensation on any other basis. But where there's unintentional indirect discrimination, the county court must not make an award of damages unless it first considers whether to make any other disposal. I think it's right to say that damages claim under the Equality Act, certainly for the types of cases that I do, which involve homelessness and community care, are in their infancy. It's interesting to note that lots of cases do get settled. I've certainly had 2 or 3 cases settled in the last year without getting to court, where there's been a claim for injured feelings in a way that a homeless person has been treated in the processing of their homeless application. And in the case of Noor and Birmingham City Council, which you may recall from the earlier slides, where the court found that there had been indirect discrimination in the way that an allocation scheme had been operated, the court invited the parties to go away and agree compensation, and compensation was agreed. So I think it is important in any Equality Act case that you are considering to include a claim for compensation. You may very well be met with the rejoinder of a strikeout application. And indeed, I'm doing a case at the moment where we are alleging breach of the Equality Act for the way in which a homelessness application was dealt with, and the local authority have applied to strike out, and that application is waiting to be heard. May I have the next slide? And in terms of what the damages are for injury to feelings, well, they are in accordance with the Vento bands, which are most recently updated in April of 2021. And you'll see that the lowest band is from 900 to 9,100, middle band 9,100 to 27,400, and the top band is 27,400 to 46,500. And it's right to say in the most serious cases, the court can go higher than £46,500 if it so chooses. So there are these are considerable damages compensation claims, and they're higher than the figures that would be awarded by the Ombudsman if any maladministration were to be found. Right. Well, I think I've come to the end of my slide. I think we have a little bit of time left for any questions, and I see that there's been comment in the chat as well.
Thank you very much, Leonie. Wow. I mean, you literally just did the whole act in an hour and 15 minutes, which was incredible. We thought we needed 5 webinars for this. You just did it in one. I mean, I have to say that was, from my perspective, incredibly impressive, very concise, extremely helpful, and also very practical at the same time. So thank you. There are a couple of questions. One perhaps naturally for each of you, and I'm sure there are going to be more questions as you answer these ones. I'm going to start with the one about damages for you, Zia, because you were just talking about it and it just seems to make sense. So the question from an anonymous attendee is compensation regularly awarded, or is this a rare occurrence?
Right. Well, I suppose the way to answer that is it regularly claimed? Because of course, if it's not claimed, it can't be awarded. So going off my own experience, well, I've claimed it, I think, in about 5 cases in the past 2 years. 4 homelessness ones and 1 allocations one. 3 of the homelessness ones settled. The allocations case, the local authority agreed to pay a sum after a finding of breach, which we accepted. And in 1 homelessness case, the local authorities made an application to strike out the particulars as showing no cause of action. So we'll wait to see how that happens, what happens there. I know with colleagues in the team with whom I've discussed this, they've also had awards of damages. I think in a couple of cases, damages that exceeded £20,000 made in respect of how homeless applicants were treated. And for example, if I can give an example of one of the cases of mine which was settled, which was where a disabled person made a homeless application, was kept in the housing persons unit all day, and then at 6 o'clock was told, well, we don't have anywhere for you because we haven't got anywhere that would do any interim accommodation that would be appropriate for a disabled person, and have had to sleep in the car overnight. That one of the claim for damages there was for breach of the Equality Act, and the local authority simply settled it. So I don't know how helpful that is as an answer. I think it's a developing area of jurisprudence.
One that's only going to develop or continue to develop if enough of us make the claims in the first place. So I think we've got that message, and thank you very much. Certainly it's one that's I've tried to take to heart. Leonie, question about the PSCD, quite an interesting question about mandatory EIAs, equality impact assessments.
Yeah, so I've seen the question. The issue is, as Miranda says, that
please don't assume everybody's read the question, incidentally, Leonie.
Sorry, right. So the question is basically that there's a mandatory requirement in Scotland for public authorities to undertake equality impact assessments, and there are regulations as to the form in which those should be carried out. Those don't apply in England, but that doesn't change the substance of the duty. And the way I think that what's required is set out very clearly in several cases, particularly Bracking and Brown. And one of the key requirements is that the decision maker has to evidence that the duty is being complied with, what steps have been taken, what consideration has been given to the relevant factors, and how has the duty been exercised. And I think it's very difficult for a public authority to show that that duty is being complied with proactively before formulating the policy or taking the decision, unless there's something in writing. And of course, there's no there's no requirement for a specific form for that in England, but you've still got to do it. And I think that it should be sufficient simply to point to the absence of an impact assessment and say, actually, what Bracken says is if you can't evidence that you've done it, you haven't done it. You certainly haven't done it in substance and with rigor. So I think that actually just simply pointing to the substance of the Section 149 duty as interpreted by case law is usually enough to get some form of compliance. The question then arises, what's the quality of that assessment going to be? But that's a separate issue as to whether the relevant factors have actually been considered properly. For example, in a recent judicial review claim we had involving asylum accommodation, the equality impact assessment was carried out, explicitly stated that asylum seekers with protected characteristics are not to be compared with British citizens with protected characteristics, which as the starting point for the exercise of an equality duty is frankly shocking. So, the question of whether the purpose and the substance of the duty is being complied with, I think is separate. But in terms of what effect do the absence of specific requirements for the form of that have, in my view, is not much in practice. And I just want to, I just wanted to second.
Sorry, Lena, I just wanted to add one point to your answer, with which I wholly agree. The problem I found with equality impact assessments is that certainly now local authorities or public authorities carry them out at the beginning, and then so they may have done one in 2015 or 2016, and then they think that's it, we've done what we needed to do, and they never look at how it's actually working out in practice. So there's no monitoring and there's no consideration as to whether the initial equality impact assessment lacked anything that needed to be considered. Because I think it's easy for a local authority to say, well, look, we can't be expected to take everything into account. You can't expect the counsel of perfection in an equality impact assessment. Well, we're sort of having to consider hypothetical circumstances. And in my experience, courts have been sympathetic to that line of argument. However, if they then go on to have to say, and also we haven't done any monitoring to see how it worked out in practice and whether we needed to do another one, I mean, there's no magic in the term equality impact assessment, then they are going to be in breach of the public sector equality duty. And I think, the asylum seeker case, which I think you appeared in, that you may have been referring to, lack of monitoring there was found to be something that was particularly egregious.
Yeah, we ended up, this is the Napier Barracks case, we ended up not pursuing the Equality Act points at the final hearing, but we did initially bring it on the basis that there was a breach both of the public sector equality duty and the reasonable adjustments duty. And one of the problems with it was that the Home Office position was, we don't know how many people with disabilities are accommodated in the barracks, because it's up to them to tell us they've got a disability, and we don't know if people are doing that or not. And I think that's quite a common attitude, particularly in asylum support cases, and to some extent, I think, with community care cases, where you have a sort of sifting or filtering policy applied to allocation of a service or allocation of resources, but you're not monitoring who's actually getting the service or the resources. And then you can't evidence that you've complied with the duty. So that itself is an unlawful approach to delivering the service. And I think that's actually quite a broad-ranging and powerful argument that's quite useful. But I also wanted to second what Zia said about damages, which is that if I am pleading as substantive, you can't claim damages for a public sector equality breach, but if I'm pleading a substantive equality duty, particularly reasonable adjustments, I will always claim damages in public law, and there's no point to doing it if you don't do it in private law. So my experience is that those will 9 times out of 10 will settle at a very early stage.
Got a very interesting question here from another anonymous attendee. Should we be regularly arguing discrimination in community care cases concerning the provision of services? I wonder if, in answering that question, you might think about the sort of deeper issue, which has cropped up in a few discrimination cases, both concerning the PSED and direct and indirect discrimination, particularly in the context of disability, that sometimes the courts say, well, when you're dealing with something like, you know, community care, which is primarily concerned with people who have disabilities, then that of itself sort of demonstrates enough regard to disability-related issues. And maybe sometimes practitioners too sort of look at something like community care and think, well, this isn't a place where we need to think about how disability is treated discreetly, because it's kind of ubiquitous in the whole area. And certainly in some cases like McDonald's, you know, which was the famous Article 14 case, you know, that was partly the House of Lords view. They said, oh, well, come on. I mean, the whole assessment here is of a disabled person that must of itself demonstrate compliance with the PSED. I wonder what you think about that sort of line of reasoning, and what your straightforward answer is to the question from the questioner: should we be regularly arguing discrimination in community care cases?
Zia, do you want to start?
Yeah, okay. I'll have a go at that. So I would be, having said we should be arguing them in all cases, with community care cases, I think I would be careful, because it may be more difficult to establish discrimination in a community care case than, say, in a homeless case, where the community care services are well, it will be said, are being focused towards the disabled person. But having said that, if there is discrimination in the provision of services for disabled persons, then I see no reason why you would not include a claim for damages, but be sure that you are clear in your mind as to what the discrimination is. Merely failing to provide a service under the Care Act of itself, without anything else, is unlikely to be discrimination, where the local authority have conducted a lawful assessment under the Care Act, for example. But if you can show that there has been discrimination in the way that services have been provided to a particular category of disabled people, or in a particular case, and remember, these things are intersectional. So you may have a disabled person who doesn't speak English, who finds it more difficult to access community care services, or wasn't perhaps able to put forward their needs properly, so that the assessment wasn't properly carried out and it didn't contain all the relevant information. So all the services that should have been provided weren't provided. And in that type of intersectional protected characteristic case, I see no reason why you would not be claiming damages there.
Yeah, I'd agree with that, and I think there will be particular, like, framing your PCP is going to be really difficult and will require a lot of care. I think there are particular types of situation which might lend themselves quite well to that. So one is going to be, as Zia said, accessing community care and the way in which assessments are carried out. So if you are carrying out an assessment that involves, you know, a verbal interview with the assessor, which is quite common, there might well be a disproportionate impact for someone who has whose particular disability prevents them from participating in that effectively. With the way in which services are publicised, with the way in which the PSED is complied with in particular, I think there's probably some scope for doing that. And I also think the other type of situation will be changes to services. And I think that was unfortunately unsuccessful in McDonald. That what prompted that was a shift from waking, I think from memory, waking night care to incontinence pads. And there may well, again, you'll go back to issues about how you select the comparator group and selecting the particular type of disability. But I think you are quite vulnerable to justification defences where community care is concerned.
Could I just make an additional point that occurs to me, which is, as Leonie has quite rightly said, breach of the public sector equality duty does not lead to a claim in damages because it's excluded. But breach of the public sector equality duty might be relevant in establishing a failure to make an anticipatory reasonable adjustment under Section 29. So it could be brought in under Section 29 and give rise to a claim for damages. So we don't, neither of us want you to go away from the seminar thinking that breach of the PSED will not lead to damages. It won't on its own, but it may be a very important building block in a Section 29 claim. And that would be relevant in community care as anything else.
Absolutely. And I just want to pick up on something that Joe Latimer said in the chat, which is beware the statutory charge. So not just beware the statutory charge for legal aid in damages claims, but also obviously there will be claimants who are entitled to means tested benefits who may be affected, whose eligibility may be affected by an award of damages, in which case the point of bringing a damages claim is perhaps less clear.
Thank you. I mean, just if I might just have an indulgent moment for a second and pick your enormous brains on this, particularly from the question of tactics. I mean, Sia, what you said a moment ago about the relevance of a failure to comply with the PSED and how it might impact on a reasonable adjustment claim in sort of terms of lack of anticipation. I mean, it seems to be fairly well established in the case law too, that if you're seeking to establish that a form of indirect discrimination is not justified, that if you can demonstrate that the difference in treatment wasn't considered at the time of the relevant act, that is likely to improve your prospects, or rather reduce the prospects of the defendant proving that the discrimination is justified. So a failure to comply with the PSED can have wider implications even beyond the example you gave, can't it? And sometimes what you end up with is a ex post facto attempt to justify in the form of an equality impact assessment, which I always find somewhat ironic.
Yeah.
But I mean, I suppose what I'm really asking is, how do you feel like, sorry, yeah, you're going to say something, please say.
No, go on, Jamie, please answer.
Well, I was just going to sort of raise the question, the sort of tactical question, if you're looking at a discrimination challenge, you think there might also be a PSED challenge. Do you bring the PSED challenge as a separate ground of challenge, or do you just confine yourself to the straightforward discrimination challenge, which of course brings along with it not just a scope of damages, but other remedies too?
I'd always bring it.
Yeah, so would I.
I'd always bring it, not least because it's not just relevant to the other forms of discrimination you might want to plead, but also to rationality. It's much easier to show that a policy or a decision is irrational if there's been no consideration of the statutory equality duties. A decision which is discriminatory can't be a rational decision, lawful decision.
Well, although I've had difficulties with that. So I had a recent case where the judge said that irrationality added nothing to the claim. And he found that a decision could be indirectly discriminatory because of unintended consequences, but nonetheless rational within the. So I've had that both ways, but I would certainly agree with you, Leonie, that I would personally I would bring the PSED because it gives you an additional weapon.
That relationship between rationality and justification is interesting, though, isn't it? Because sometimes that's said in defence. Well, it's a perfectly rational decision. You say, well, if it's rational, that's one thing. But if it were irrational, we wouldn't need to worry about arguing discrimination. We'd just be arguing irrationality. I mean, discrimination is almost rest on the assumption that the policy is otherwise rational, but it's whether or not it's rational and non-discriminatory that's the key question. And the eliding of rationality with justification seems to me to be a very dangerous trend, one that's quite tempting to judges, but is conceptually clearly completely wrong. So that's another kind of interesting feature for us. But I did think that question would produce interesting answers from your massive brains, and so it did. But I think I'm massively indulging myself here and going way over time. So I need to apologise both to you and to all of our very patient attendees who have been in the meantime posting on the chat and the Q&A just how grateful they are to you both for a wonderful session. If I can just add my own thanks to you. I know how much time it takes to prepare these. It's absolutely obvious from the notes and your presentations that you haven't cut any corners. On the contrary, you provided a really thorough and comprehensive analysis of the Act and a wonderful end to our series celebrating this most wonderful of acts. So thank you both very much, both for myself and all the attendees. To the attendees, thank you very much for coming. Massively appreciated. It's hard enough doing these things from our bedrooms, or in my particular circumstances, my mum's bedroom with her cat alongside me. But it just wouldn't be the same if it wasn't possible to know that lots of people are listening. So thank you. But I should also point out this is recorded and will be available on the website here on in. So if you have an issue later on and you can't quite remember what Leonie or Zia said, and you want to remind yourself, then please, by all means, access the recording and you'll get the answer that way. Or indeed, and I'm sure they won't mind me saying this, email them with your queries and I'm sure they'll provide any answers they can. So thanks very much. Thank you, Ray, for doing such a wonderful job putting it all on, and speak to you all soon. Bye-bye.
Thanks.
Bye, thanks, Jamie. Thanks for chairing.